A very good evening to all of you. I welcome you all to this lecture series, the demo lecture series being organized by JPAC, that is Judicial Preparation and Advisory Center. My name is Ankeeta Gupta and I'm one of the mentors associated with JPAC. And it's a great privilege to be introducing the law of contract to all of you. Now, JPAC tries to provide a holistic and an enriching experience in terms of the training that you require to become the judicial officers, to get that coveted seat at the judicial institutions, the legal machinery within the country. And it is with utmost privilege that I introduce this subject. Now, when we look at the law of contract in India, you can see that it is divided into three different components. Now, if I just share my screen, you'd be able to see the law of contract in India can be divided into three parts, as I was saying. Part A, which deals with general principles of law of contract as enshrined in your Indian Contract Act. Then there's a part B, which talks about concepts of special contracts and special situations, including agency, bailment, etc. And then there's a part C, where various laws like the sale of goods, partnership, etc. come in. Now, it is extremely imperative for all of you to note that generally in the examinations, the syllabi that is provided will indicate that it is either looking at only the Indian Contract Act or the general principles of contract. However, in some states, in some of the examinations, they do, however, indicate as to incorporating questions from part B and C, the sale of goods, partnership, even agency and bailment. Now, most of those where they have this specific provision would have listed it. And it is, and to ensure that there's no mistake in that, we at JPAC would even look at, the earlier year's question papers to identify whether or not these concepts have been incorporated. Now, when you look at the contract law per se, in my view, contract law is an extremely organic thing. The law of contracting or the art of contracting is extremely organic, and that is what we read in this law. So first and foremost, you need to focus on part A, where we are talking about formation of the contract. Basically identifying whether or not a legally tenable, enforceable agreement exists or not. Next, we move to the performance of the contract. So once the contract has been made, you look at this next stage of performance. And in case the performance, etc., does not take place, you move to a third stage where we talk about breach and we talk about the remedies that may be available for breach. Now, when I say that this is organic, it's almost like a human being born, then growing up, performing the duties, whatever that person came for in this world, not being able to do so, then there's a breach, and then there are remedies that are available. Now, when we look at these concepts, it is becoming extremely daunting for a lot of us when we are trying to understand the basic concepts and understanding what's a section 10 importance, what is consideration, etc., etc. And I would like to simply tell you one thing, that rather than looking at contract as a concept which exists only for multinationals, companies, or between important people like the government and the companies, or between the governments, etc., try and look at it from the perspective of your everyday happenings. Contract law exists in our everyday lives. And once you are able to incorporate that in your understanding, there'll be absolutely no confusion as regards the concept. Because let me tell you, law of contract forms, even though it forms a 10%, it actually gives you a lot of breather because it is simply looking at the concepts and it is driven statutorily. So you are able to master the subject You are able to understand the questions, and you are able to prepare it well in advance. And it's a simple concept. So, it will not take you much time to understand it. And we at JPAC here make an attempt to simplify the law by bringing in lots of charts, etc. Because in your law of contract, you'll find that almost everything is connected one to the other. The moment you understand those connections, the moment you are able to identify how those connections work and how you are able to develop a final contract, it will be a cakewalk for you. So that is why the stage one, where we are looking at formation of the contract, it is extremely important that you understand the basic concepts as I've highlighted here. So this basically talks about the essentials of a valid contract. Essentials of a valid contract are what? There has to be an offer. The offer has to be accepted. Once the offer has been accepted, there has to be movement of consideration. Once that happens, then you look at the legality of the object and legality of the consideration. And the moment you have a legally enforceable agreement, you reach a contract. The only addition being that you must be legally capable of entering into that agreement. And that's it. That is the sum and substance of how you will form a contract. Now, when you're looking at formation of the contract, a lot of confusion arises as to when has the offer taken place. What was an invitation to offer? That's another concept that we talk about. From whom is the consideration moving? Because, and these kinds of questions arise especially in terms of consideration, because there's always this misnomer that consideration can only be monetary. No. As per the law, consideration can be anything that has value. And when you start looking at these principles, if with your daily life, you'd realize that there's actually no fixed rule. For example, when if I want to take the services of, an internet service provider. Okay, so what do? I go onto their website, I browse a lot of their plans, and they have offered those plans. So I accept, let's say, a $299 plan, and I click on it. I've only accepted an offer that has been made to me. Now, the moment I pay the amount, I said I will take a $299 plan, right? So I pay the $299 amount. It goes to the bill desk, it accepts, and I have a valid agreement between me and the internet service provider. Correct. Now here one can say that the offer was made by the internet service provider. I accepted it and I made a payment. Correct. And that is why the payment that I made was actually a consideration that moved from the promisee to the promiser. And that's when the agreement got created. Now imagine a different situation. This time I'll take the situation of not of an internet service provider, but from our daily life. For example, I want a house to be built. Now here there are two options. One is I go to a builder and say, take my money and build my house. So here, what is it that I'm willing to offer? I'm willing to offer money, and in return, the other party, that is the builder, is willing to give me my house. It could be the reverse as well. The contractor coming to me and saying, I'm willing to build your house, provided you give me the money. Getting the point? So at the end of the day, what is most important for you to understand is that there is a promise, and that promise is based on the proposal, and that the proposal and the promise are dependent on how the conversation is going. You cannot fix it that this has to be the proposal and this has to be the promise, or that money has to be the consideration. And that distinction sort of helps you achieve the understanding of when the agreement has taken place. Now, when we are looking at the agreement and when I'm discussing the concept of proposal, promise, etc., you're all very, very aware of a very serious problem that all of us face in identifying that the agreement is being made, when we look at the concept of acceptance. I'm sure all of you know what a section 4 is, that there has to be communication of acceptance, and when communication of acceptance is complete, section 3 and 4 respectively. Now, in that, the understanding that communication is complete when the acceptance has been conveyed. Is it conveyed? No. Acceptance is complete as against the proposer when it has been put in the motion or put in transmission, the famous postal rule. So, when it is these different concepts that culminate to create one big concept of a contract. And when you're looking at that big concept, you just need to keep in mind that they are all building blocks, right? When you want to create a house, there'll be a lot of building blocks that you will put in together to create the house. So for formation of the agreement or formation of a contract, you need to consider all of these as separate building blocks which will come together and create that contract, and therefore they become extremely important. From the stage of formation of a contract, we move to performance of the contract. When we're looking at performance of the contract, it is basically what? That the contract has been discharged. Now, mind you, it can be discharged in various methods. There can be a performance, which is the most validly accepted, but there can also be a discharge of the contract by way of a breach, where the party refuses to adhere to the terms of the contract. There could also be a case of frustration. Frustration of the agreement these days is an extremely important concept, and mind you, it will form part of various questions, various examinations, for the simple reason that the COVID has told us that anytime an unforeseen situation may happen which can lead to waste any agreement, any contract that you have entered in. Correct? So that is why the frustration of an agreement, section 56, becomes extremely important in terms of what are the effects and how can you salvage your agreement. And that understanding comes in when we look at the remedies for breach. Now, when we're looking at remedies of breach, some of the most common concepts are in terms of the kind of compensation or the damages that you're getting. When you're looking at damages, you're looking at liquidated or unliquidated, which essentially means what? Pre-decided and post-decided. Something that has been pre-decided that, okay, if there's a breach, you're going to pay me an X amount of money, or you're going to return the original amount at an X% interest. Correct? That's what would be your liquidated damages. Unliquidated damages would essentially mean and depend on the kind of damage that has taken place. Correct? And it will be again negotiated. So again, a new set of agreement will get created. Then we also look at various concepts of an injunction, specific relief, where we ask the other party to say, no, you must necessarily perform the agreement. So there has to be specific performance. Now, when you're looking at all of these concepts, it is extremely important for you to limit yourself to stage 1, stage 2, stage 3 in your mind. Do not allow your mind to mix them, because the moment they get mixed up, you will get confused in terms of your basic factual situation. And when we're looking at the illustrations, please be very, very careful of the fact that illustrations have to be read on an as is where is basis. You cannot read more facts into it, right? And when I say that, you cannot read more facts into it, I mean by saying when you discuss a lot of cases, right? Various illustrations, you tend to say that, no, there seemed to be an intention. There seemed to be an obligation. But what you have missed is that essentially the contract, that illustration does not mention any kind of an intention or an obligation. And that is why reading the MCQ options also becomes important, because it is, if you're not able to understand or if you feel that there's a confusion, the the objective options will make it more clearer to you. But what is most important is to never read more than what is required into it. Read the illustration on an as is where is basis without having any understanding of the background, or without attempting to have an understanding of the background. Now, having said all of this, I want to devote a slight 1 minute to the techniques that we follow at JPAC when it comes to ensuring a holistic and an enriching training experience for all of you. Here, we make an attempt to reduce your wastage of time as much as is possible, and therefore we are completely online. We ensure that you are able to access these classes from the comfort of your home, with your comfort and your understanding being of paramount importance to us. Because the moment you are comfortable, you will be able to devote mentally and physically more to the exercise, the course and the exercise and the training. Secondly, during the classes, we make sure that there is an active interaction. Of course, there may be sometimes practical difficulties, but we make it a point to have some interaction in the class so as to ensure that that we are on the same page in terms of studying a particular topic. We also encourage raising of doubts. We try and limit it, but it will only be for your sake. Otherwise, there's no limit to the questions that you can ask. There's no limit to the number of doubts that you can raise, right? Thirdly, we make it a point that there is a refreshing exercise for you after the class. So for instance, in law of contract, after the class, there'll be a set of 5 to 10 questions that you'll be required to answer. Those questions will essentially pertain to the class that we have done. But why it's important is because it will help you in refreshing the memory immediately. So it's like a concept of look, cover, write, check. So you have understood something quickly. Secondly, it will also help you understand whether there is a gap in your understanding in terms of what has been taught and in terms of what you have understood. The moment you take away those gaps, you are on a successful path of study, of enriching yourself. And with these questions, the fourth most important thing that comes in is that if you find that there is a gap in the manner in which we have taught, you would be able to identify that and understand it in the next class. Correct? So this way we are giving you an opportunity to retain most of the things that you have learned there and then. Okay. We focus a lot on the practical training. The practice questions are extremely important, and therefore we have devised a mechanism where there will be periodic practice tests for you, and that will ensure that you are able to do as much practice of the questions so that during the examinations you don't get tired. One of the major reasons for a lot of people to not be able to achieve their attain that goal is that even though they have studied very hard, they have looked at various things, they have looked at almost all options that are available in terms of preparation, but on the day of the exam there's a certain exhaustion that sets in while attempting that examination. So we'll make sure that you are trained enough so that at least exhaustion does not take over, and you're able to attempt your examinations with utmost freshness and without any exhaustion, right? So that is one of the goals there. Now, if I were to come back to the law of contract, and if I were to talk in terms of the formation, performance, and breach, to take in one of our daily lives examples, like I gave you the example of me purchasing a service provider's service, correct? Now, in that, what have I said? That they offered a plan, I accepted the plan, and I made a payment for it. So a legally tenable agreement has been entered into between me and the service provider. I've become a customer. And there's also a contractual obligation and a contractual right that has arisen between the two of us. So here what will happen is that in case there is a breach, in case the service does not work, in case the internet does not work, I can go back to that service provider and say, look, boss, this internet service is not functioning properly. And there's a breach in the services that you promised. There's a breach in the contract because the services that you promised are not functioning. So what is the solution? Either there'll be a case of rectification, or I will get a compensation, or I will be, returned the money, correct? Or I will be given a new connection. What is this? This is your damages. This is your rescission of contract. This is your specific performance, right? So the moment you bring in, your concepts and you start understanding them in the manner that is in the life that is generally available around you, the law of contract will become an extremely simple thing. And to ensure that the real life examples that we discuss have a judicial standing, have a precedential value, we will be discussing the cases as well, right? So when we discuss those cases, we discuss those cases in a manner that you are best able to understand them more as instances for which you need to find a solution. Because the moment you start looking at the law as a solution to the problems that exist, your retention of the law will also increase. Because otherwise, you'll keep looking at it as a drudgery. Oh, I have to remember section 2A. Oh, I have to remember section 10. But the moment you start looking at it as the basis for looking at a solution to your contractual obligations or your rights in terms of the contract that you have entered with somebody, then it will not be a drudgery. Then you'll remember those ingredients as well. Correct. And mind you, in your examinations, in your, specifically in your preliminary examinations where there are MCQs, etc., it is extremely, extremely important that you understand the ingredients of each section very, very carefully. Because unless you don't do that, unless you don't look at those illustrations with the ingredients, unless you don't do a reconciling, it will be extremely difficult for you to be able to understand the concept and answer the questions, right? And therefore, I would very, very strongly suggest that please come to us. If you want, you can have more demo lectures, and we would be happy to share. We would be happy to clarify any of your doubts, or that you may have doubts or questions or clarifications that you may have. We would be happy to answer those, and I'd be happy to see you, right? So I would stop here, and in case there's any doubt with respect to the things that I have raised, the things that I have discussed, I'd be happy to discuss these more of these with you. And yes,